Why are the farmers protesting? Why have these agrarian bills come to the first page? What do these farmers want from the government? Were these reforms baseless or were these the need of the hour? All these questions come to our mind when we are switching on the TVs these days. Hello everyone, my name is Samanvi and in today's video we shall be understanding the controversy around the three farm bills that were passed in the parliament on September 20 and 22nd of this year. For convenience, I have divided today's video in four parts. In the first part, we would understand how has the sale of agricultural produce been happening. In the second part, we would understand how the sale would happen post these 2020 amendments. In the third part, we would understand the lacunas and critically analyze the farmers' bills, the three farm bills. And the fourth part, in the fourth part, we would see what are the recourses available to safeguard the interest of these farmers. Now, let's first look at the constitutional provisions that are involved in this particular sector. Agriculture, markets and fairs and trade and commerce within the state is a part of entry 14, 26 and 28 of list 2 of the 7th schedule. That means it falls essentially within the state government's control. Now let's look at how has the farmers agricultural produce been sold until now. Let's first look at how post 1947 post independence this was done. Post independence, the farmers were directly selling their crops, their produce to the consumers. Now, what was the problem here? The significant problem was the vicious cycle of debt. The banking system, since it was not a proper one, the money lending system had been affecting the farmers. They had to take loan at a high rate of interest, exceptionally high rate of interest. Due to weather conditions, they could not recover their money from the sale of their agricultural produce. Had to sell their agricultural produce to the money lender at throwaway prices, again leaving them to in a situation to get for needing more money, hence going back to the money lenders. Now, this was a vicious cycle of debt in which the farmers were caught and hence was creating all the troubles for the farmers. Now, the reform that was needed were two significant reforms that were brought was APMC and the second was MSP. Now, what is APMC? APMC is the Agricultural Produce Market Committee, under which there would be several market yards. Now, each state would have their own APMC, and within that APMC, there would be small different areas which would have their market yards. Now, there are two things. The first thing is that farmers in that specific area can only go to sell their agricultural produce within this specific market yard under their APMC. The second thing, only the registered traders within the APMC premises are eligible to purchase the agricultural produce from the farmers who are coming to the APMC market yards. Now, to bring the agricultural produce to the APMC market yards, the transit cost has to be borne by the farmers. Now, the next question arises is that when the farmer comes to this APMC market yard, which is the only resort where he can sell its produce to, the monopoly issue comes in. Now, with this monopoly issue, the next concern is the price. How is the price determined at which the farmer would sell its agricultural produce? Now, what essentially happens is the mechanism of price discovery is that there should be a with the MSP system, which is the minimum support price, there should be a price guarantee which would act as a safety net that below this price, the price discovery procedure, the determination process would not start. Now, this price discovery mechanism would be starting from the MSP, and the auction method would be used. That means all the traders in the market yard would call for an price discovery. Now, what is the problem here? The problem that arises here is that traders pre-decide and form cartelization behaviors, which then implies that, for example, if the minimum support price for wheat per quintal is rupees 100, which is the minimum support price where the auction would begin, the traders will not quote a price above rupees 100. So if three traders are there and three traders quote rupees 100, farmer has no other option but to sell at rupees 100. So essentially the MSP becomes the maximum selling price. Now let's look at what does the supply chain look post these amendments. Now there would be a farmer would have to go to the APMC to approach the traders. What essentially was happening was that they would need commission agents who would facilitate their transaction with the traders. Now, On record in the records of law, there is no mandate that the farmer has to pay a commission to the commission agents necessarily. But what essentially happens is that with the monopoly status, these commission agents enjoy 3 to 6% of commission. Now, post this, when the traders get the price discovery based on the whole auction procedure, to complete the transaction, we need transaction agents. Now, these agents again charge from 3 to 6% of commission, and then with the transaction be marked complete, the residual amount is given to the farmers, which again leaves them with minimal cost recovery. Then the traders would leave them. Then the agricultural produce would go to the wholesalers, the vendors, and other people who can buy this, and then ultimately to the consumers. Now, this includes a lot of middlemen, a lot of intermediaries, hence causing the profits which were essentially originally should be have been gone to the farmers would go to the other intermediaries. Now let's look at post 2020. Now three bills were introduced and passed and given assent by the president. Now let's look at the first bill. The first bill is the Farmers Produce Trade and Commerce Promotion and Facilitation Bill. Now essentially, if you look at this, the title of the bill itself clarifies that the farmers produce, that means the agricultural produce, the trade and commerce of that would be promoted and facilitated. Now let's see how they have tried to promote and facilitate this. Now, the first thing that this bill has tried to do is that they have tried to tried to permit the intra and interstate trade of the agricultural produce, which was earlier only limited to the APMC market yard. The second thing that they've done is that they've introduced that electronic and online trading platforms can be set up for trading in the agricultural commodities and agricultural produce. The third thing that they've done is that they've removed the market fee that was payable in the area in the market yards of the APMC. Now, essentially, what this bill on the papers has tried to do is not remove APMC, but what this bill essentially in real life would do is that it would bypass APMC. So we have drafted a mechanism that we can bypass APMC and go to other buyers. Now let's look at the third bill. The second bill talks about farmers empowerment protection agreement of price assurance and farm services bill of 2020. Now, if you see the title itself talks about the farmers agreement. Now, what would this agreement be about? One is price assurance. The second would be the farm services. Now, this farm services has been an extension of the scope of this agricultural sector, which means that supply of seed, food, feed, fodder, agrochemicals, machinery, technology, advice, non-chemical agro inputs, and such other inputs are also included within the purview of the farming service within the farmers agreement. Now, essentially, this bill permits the contract farming. Now, that means that a contract can be entered between the buyer and the farmer, and this agreement would mention the price. Now, it would mention the price at which the price that is predetermined before the crop or produce actually comes into existence. The second thing that it would assure a guaranteed price. Now, this guaranteed price would be paid irrespective of whether the produce has been as per the quality that was mentioned. For the reasons any reasons that were beyond the control of the farmer itself. The third thing that it provides for is the dispute settlement mechanism. Now, if there is any dispute settlement mechanism, that has to be mentioned in the farmers agreement in itself. Now, this agreement would provide for three-tier dispute resolution mechanism. One is setting up a conciliation board. If dispute remains unresolved, there it can go to subdivisional magistrate. If you're not resolved, you can go to the appellate authority, which would be headed by the collector. Now, with this, you can have a dispute resolution mechanism, and then all the disputes arising from the contract with this farmers agreement can be discussed here in itself. Now let's look at what the Essential Commodities Amendment Bill proposes. The Essential Commodities Amendment Bill, what it has tried to do is cereals, pulses, potatoes, onions, edible seeds, oils, etc. would be removed from the essential commodities list. Now, what is the meaning of putting a commodity in the list of the essential commodities? It essentially means that you cannot stock an essential commodity within your premises. That means if cereals, pulses, potatoes, onions are not within the list of essential commodities, you can You can stock these commodities within your own premises, and this would have heavy implications on the market factors that would vary, that would influence the price of the commodities that you are selling. The second is the stock limit. Now, what would be the stock limit? The stock limit would be, or it requires that the imposition of the stock limit on the agricultural produce must be based on the price rise. Now, this price rise would be 100% increase in the price. If there is a 100% increase in the price rise of the horticulture products, or there is a 50% increase in the price rise or retail price of the non-perishable agricultural food items. Now, please mark this word food items. We'll discuss this in the coming minutes. Now, let's look at what are the lacunas in this whole reform. Now, the first lacuna is that no MSP security has been given. So there is no guarantee that when the farmer is entering into a contract with the buyer, the one, there is agreed that there's a price assurance, but there is no price assurance that the minimum support price would be given. That means there is no threshold limit below which the farmer cannot sell or the buyer cannot purchase from the farmers. This comes from the fact that the farmers are at a low bargaining power. See, considering that a lot of agri-tech firms are being set up, corporate giants are entering into the agri-tech business. What is essentially being done is that farmers' bargaining power has gone down to little or less, especially if they are the small farmers. And the next lacuna is that there is a lack of regulatory authorities. Now, under the APMC setup, there we had a lot of traders who had to be registered, other warehouses that had to be registered under the Warehouse Development and Regulatory Authority, which would provide the infrastructure facilities to the farmers. Now, what would essentially happen is that there is a lack of regulatory authority with this whole setup. Also, that if you say that there are different regulatory authorities at different stages of the whole procedure, whole arrangement, there is no one regulatory authority, one common regulatory authority that would regulate the multiple regulatory authorities. Now, the third part is that this whole system is unsuitable for contract farming, that the farmers are incompetent considering their awareness, considering their lack of knowledge when it comes to negotiate, lack of terms in which they can set up the price, how they can negotiate. It feels like the whole setup would be unfriendly for the farmers. This is why the farmers are protesting, and in the light that they're unaware about how would this whole setup work. Now, the last is the dispute resolution mechanism. Now, the significant problem that I have with this dispute resolution mechanism is that it is governed by the executive branch, which means that essentially the intermediaries who were allegedly a part of the political parties, who are people who have connection with political parties, hold those positions. Similarly, in the dispute resolution mechanism, the executive branch is involved, wherein you can say that this whole dispute resolution mechanism will not be free from political influences, against subjecting the farmers to unnecessary political dilemmas. Now let's look at what is the constitutional challenge to this. Now the essential constitutional challenge to these farm bills is that what has the state tried to do is that what has the center tried to do is that they have encroached upon the state's right to legislate. Now it's a clear infringement of state's right to legislate. Why? Because they have used certain words in a manner. For example, they have used trade area and food items that I have mentioned in the earlier slides, that they have used these words in place of the words that were falling within the ambit of the state list, to clearly bypass the authority of the state which they had within the power of the state list. Now, what also they've tried to do is that they've tried to construe the food items which essentially fall within the concurrent list, but the agricultural commodities are different from the food items, hence taking away the power from the center to legislate on the food items, on the agricultural produce. Now, this is where change of words has been done to encroach upon the state's power to legislate. Now, the next thing that they've also tried to do is that Section 6 of the bill says that the state will not charge any market fee. Now, to charge a market fee fell within the ambit to impose a levy or a fee from the farmers on the trading of the farm produce was a clear domain of the states. Now, when it's a clear domain of the state, what they've essentially tried to do is they've tried to encroach upon the state's power to legislate. And what they've tried to do is that when they've tried to introduce the intrastate and interstate sale, what they've tried to do is that they've tried to take the power from the state government itself and bring it down in the ambit of the center, which essentially was not the purpose of the constitution makers while they had included agriculture, markets, and trade and commerce in the state within the ambit of the state legislature itself. Now, what can the states do to provide a safeguard to these farmers? Now, now in this part of the video, we are trying to look at what can be done by the states to protect in amidst the whole of this chaos. Now, we acknowledge that the state government has finagled its way into the legislation by misconstruing its authority on the food items, a subject which was in concurrent list as authority over the subject agriculture. The food items and agricultural products are distinct categories, as many agricultural produce in their raw forms are not food items and vice versa. Now, what is the recourse? Now, if we look at Article 254, the Article 254 provides that state can legislate on matters given in the concurrent list, subject to the condition that the state's legislation must not be inconsistent with the Centre's Act. Now, what am I proposing is that the state can create a legislation on the APMC and on the sale and creating a market of the agricultural produce to ensure that all the interests and all the interests and concerns of the farmers are met with for doing what? Now they can codify the MSP and the related guarantees over and above what center has proposed. They can also strengthen the dispute resolution mechanism by including judicial protections to by including judicial protections to the dispute resolution mechanism. Also, they can bring in APMC's position and role in a clarified manner. They can codify that. They can ensure the farmers that this will not be done. Now, with this, they can go to the states also have the right to go to the Supreme Court challenging the bills under Article 32, saying that it's a violation of of the constitutional provisions. We've clearly seen how they have encroached upon the state's power to legislate. Again, the petition has been filed by Karnataka's chief minister, which is a Congress party government, and they can essentially look at the whole concerns around the constitutionality of these bills. I hope you liked today's video. Thank you.